Every good law student knows that equity law developed in the Chancery Court in the 14th century, and that it was intended to be the law of conscience. What role do 14th century legal principles have in the modern world? ACCC and Berbatis, heard in the High Court of Australia, was one of three cases which really established how modern equity law works. The others were Amadio and Commercial Bank and Waltons and Marr. In this case, Mr and Mrs Roberts owned a fish and chip shop in Farrington Fair Marketplace in Perth. They wanted to sell their business, but the lease was up for renewal. They were also involved in another quite separate legal dispute with the shopping centre owners. They asked the owners to renew their lease with a condition allowing them to transfer the lease to any new owner of the fishos. The owner came back and said, "We'll give you the lease you want, but only if you cease your involvement in the other legal action." The ACCC took action, arguing that the owner's conduct was unconscionable within the meaning of Section 51A of the Trade Practices Act 1974, which said a corporation must not, in trade or commerce, engage in conduct that is unconscionable within the meaning of the unwritten law. The unwritten law, of course, means equity law. The ACCC view was that the negotiation between the Roberts and the owners was unreasonable because of the massive imbalance in bargaining power. Was this unconscionable conduct? Well, the High Court said no. They said it's entirely normal for there to be unequal bargaining power in a commercial deal, and that unconscionable conduct is there to prevent people taking advantage of a special disadvantage, not a normal one. Justices Gummow and Haynes said the special disadvantage is one seriously affecting the ability of the innocent party to make a judgment as to that party's own best interests. Mr and Mrs Roberts were under no disabling condition which affected their ability to make a judgment as to their own best interests. The result of this case, along with Amadio and Waltons and Marr, is that unconscionability is the linchpin of modern equity law. Modern equity law is called upon by a range of statutes to prevent the wicked from taking advantage of those under a special disability. A 14th century concept, but still relevant and powerful.